everybody. Welcome to week 205. So how about that today? We've got the effervescent Jack Santinello, and we've given Adam a day pass. We're actually doing a communication seminar with Johan Kornoff from Cape Town, South Africa, here in our offices. So that's why I'm doing this out of the innovation conference room. But anyway, so we got a lot of stuff to talk about. I am trying to see. Are you seeing everything here, Jack? They've shifted some things in the Zoom thing. Oh yeah, they've just changed things up on me. Just when you think you got everything down, they change stuff on you. So now I'm finding all my controls here. All right, cool. So one of the things that we are going to be talking about are some of the changing legislation impacts for you. Possibly if you have any employees that could be impacting you, overtime rules, as well as non-competes. So we thought, man, what a perfect time to have a lawyer on with us today. So anyway,
Yeah,
it's
there's
good.
many times where we are like, okay, what are we going to talk about this week? I think we have plenty to talk about this week and maybe even runs into the following week. So yeah, absolutely.
Yeah. So, and we had a whole bunch of people that were massively late for our 9 a.m. start time this morning. And evidently something's going on because 77 was a parking lot, usually is anyway. But I heard that Biden is coming to town. So I didn't know if that was part of the deal or not, but to deal with the tragedy and senseless shooting of 4 law enforcement officers in our fair city. Still so frustrating to know that that kind of crap is going on, but it is the world in which we live, unfortunately. So on another note, before you get into this though, Jack, I spent 3 days at the Purpose Summit that was here in Charlotte. It's been at Notre Dame for years and then up in Detroit before that, but they are looking to actually move their headquarters to Charlotte, North Carolina. And this was an amazing 3-day event. We had people from, I think it was 33 states and multiple countries that had flown in here. So the CEO, he was CEO of WD-40 for 25 years, just stepped down a year ago. From people like that to, if you ever watched The Informant, that movie, that is about a guy that was there, and he is here in Charlotte, North Carolina, reports directly to Frank Harrison III at Coca-Cola Consolidated, and he runs T Factor. Like, his story is unbelievable. The Hollywood story does not do it justice because there's a massive redemption story in that story. But just think, when you were 32 years old, he was named division president of Archer Daniels Midland, given a Falcon 50. Like, which of these Falcon 50s do you want? New one. Lived in a 13,000 square foot house with 8-car garage. Went from making $3 million a month at 32 to $20 a month in federal penitentiary for 8.5 years. Like, and that was after he wore a wire for three years for the FBI. I mean, unbelievable. So we had people like that, but people that are running businesses and smaller businesses, C12, it was really amazing. It will be here in Charlotte, North Carolina again next year, May 13 through 15. Tickets they're doing an early bird right now, about $750 a ticket. And I think they were like $1,200. And that's probably what they'll be, but it was at Camp North End. It was unbelievable. And just while we see all the junk and the darkness that's happening in the world, it was beautiful to see beacons of light where people are actually doing something about living on purpose and having cultures within their companies that were driven by purpose and a greater good beyond just what they're doing. So one other quick story I got to tell you. So this is a guy that's here in Charlotte. He has a company that's here and also in Kansas City, and they have a lot of their hourly workers are based out of their distribution center in Kansas City. A lot of them don't have a lot of money. They live in some pretty tough areas of town, and he wanted to do something about it. And so he completely went to his 8-person steering committee of people that live in Kansas City and that are affected by that as well. They did a 4-hour tour, and they're buying this what was a Safeway in the middle of a tough area, very hot in the murder map world. And he said, I will do whatever you guys want to do, but I want to do something great. And they voted 8-0. He did not get a vote. Let's do it. And it's a very dangerous place. He's going to be giving like $10,000 per employee so that in that area, so that they can have money to like buy a house. They're going to actually start building houses. This thing will be done and renovated in 2026, early 26 or late 2025. Unbelievable. But so just when you think, hey, the world is terrible, no, there are good people. There are good people that are making differences and making positive ripples. So it's really cool. So I just encourage you, put it on your calendar, make a way to make it happen. May 13th through 15. There's nothing in it for me, but other than I just like to see more people encouraged, more people that are ripple makers realize you're not alone. And what was really cool, we had some 2 of the 3 finalists for the Purpose Awards were BGW clients that I helped bring in, which was so fun. So anyway, enough about my little preamble. You guys know the drill. Oh, somebody's already hit us up in the chat. Oh, it's thank you, Gerald. I'm glad your AI assistant is taking notes. So that was in the chat. I guess that's probably a regulatory thing that they have to do now. That's fine. But Gerald, always good to have you on here. You guys know what to do. Hit us up in the chat. And if you have questions, let us know there too. So in the Q&A, it's funny, they've changed the whole, like the navigation
The
system
dashboard,
here. Yeah.
yeah.
So I'll get used to it, and then they'll change it again.
Yeah, well, so a couple kind of opening comments for me. First, yes, there are some amazing people both here in Charlotte and elsewhere that are doing some really fantastic things. My latest thing is there's a project called Spark Centro, and it is a facility over on Albemarle Road near WT Harris, and it is an incubator for businesses. It's not a social welfare kind of facility. It is for people to come and bring their businesses there and incubate it and grow and learn how to read financial statements more accurately. I mean, those kind of things. There's some big players that are involved in it, like the major banks, so Wells, B of A, Truist, have poured money into this because it's an underserved community. And you know, the Latinos and non-white population, I mean, it's just increasing, and there's a huge discrepancy between opportunities for certain races. So and I say that as and I can say that I think it's being recorded, I'll say it anyway because I've said it out in public before. I may look like a white boy, but I am 50% Colombian and 50% Italian. So I got the mafia and the cartel in my blood. So but that's and then also on the shooting a couple days ago. So I'm friends with Chief Jennings. I'm friends with the DA, and they are good people trying to keep us safe. And there is an issue with the judiciary in the criminal justice system that the repeat offenders are being let. I mean, they spend 15, 20, 30 minutes, an hour being processed by a magistrate, and they're back out on the street. Statistically, you look at the people that are committing crimes, many of them are multiple offenders, and a
Mm.
lot of them are young. And I think that there was one example that I heard yesterday that it was there was someone who was caught or charged with like over 100 break-ins, young person. It was a gang initiation, and apparently she passed. And then she was given a gun, and then it escalates into armed robbery. And then so, there's just all kinds of things that go on that way. And so I know that law enforcement is doing all that they can to keep us safe, and that is a high priority for them. It's just that there are others in this town, and I don't want to be critical of anyone or any city council or county commission, but they have competing initiatives. But if you're not safe, it really doesn't matter if there's affordable housing. And I don't want to
Right.
belittle affordable housing at all, but you need to be safe in order to prosper,
Yeah.
and safety should be paramount. So that's my comment on that. And so on to the encore presentation. So I tried to get my one of my employment law partners to come on because he obviously would know the most about all of this stuff, and has published a few things. And then also I have another partner in our Tampa office who published stuff on the exemption salary thresholds, but wasn't able to get either of them on. So you're stuck with me. So I'll
So
do
do
the
you
best that
think
I
that they
can.
thought that we were going to dress them in like Dunking's outfits or anything like that? Do you think they were
Yeah,
shying away from
possibly.
that?
Yeah, that the word has gotten about around. So yes. In fact, I saw Michelle on the way in, and because we're doing a presentation later this afternoon together, and she kind of looked at me like, "Oh, okay, that's what you're wearing." I think she was expecting me to wear the Dun Kings outfit, which I probably should have just at the beginning maybe. So, but I think that I will. I mean, I may as well use that. So maybe that'll be my uniform next time. I'll special appearances with the Dun Kings. So
Yeah.
let's start with the FTC rule on non-competes, and I'm going to give you the Cliff Notes version per one of my partners, and then we can go kind of diving into the details. So a couple of just again notes. The new rule doesn't go in effect until 120 days after it's published in the Federal Register, which is the way that most things get done with regulations. They go through comment periods. They internally, then externally, the public can go, and so this is published, and then they come up with interim rules and final rules. And so this is a final rule as promulgated by the Federal Trade Commission, but it can't go into effect until it's been out there published for 120 days. So essentially 4 months. It hasn't happened yet, so the clock hasn't started. For senior executives, namely those in policymaking positions, so kind of upper management-ish, and that person is making more than $154,161 per year, the rule only prohibits new non-competes. Okay, so we're going to talk about what this applies to, and basically it's across the board unless there is an exemption. And one of the exemptions is that if you have a higher paid executive that is already in an enforceable non-compete, then that it does not get invalidated. So we'll talk about that. For everyone else, the rule prohibits new non-competes and enforcement of existing non-competes. It requires that a certain communication be sent out to employees about enforceability. So you have non-competes in your documents, and you get to tell your employees that, yeah, thanks for signing it previously. Yeah, we probably gave you a little extra money to make sure that there was sufficient consideration for enforceability of that. But yeah, it doesn't mean anything anymore. So I shouldn't say it that sarcastically. I mean, I see both sides of it, and we'll talk about the economics of both sides. But I mean, I know for my clients that have invested in something in a business in somebody, they don't want that person taking that stuff and going elsewhere. So that's a preview of my kind of personal professional position on that. The rule does not prohibit other restrictive covenants such as non-solicitation of customers or of fellow employees. So understand that there is the non-compete side of it, and then there's the solicitation side of it, which has kind of two categories, which is solicitation of your employees, your coworkers or former coworkers, and then solicitation of clients. And it usually refers to the assertive solicitation of clients, not ones that happen to find you at your next job. If you aren't the one that's out there saying, hey, either directly or indirectly or quietly saying, hey, wink, wink, I have a new phone number, come give me a call and we'll talk about the kids or something like that. So those things are still not allowed. So let me go a little bit deeper into kind of what's been going on. So the background story is that, and this was published late last week, more than 15 months after publishing the proposed rule and after receiving more than 26,000 public comments on this proposal that first came up in January of 2023. So again, over a year ago, FTC at long last unveiled and approved its final non-compete rule via a 3-2 vote. So barely passed. And I admittedly did not know that there were only 5 people that were basically putting this on the rest of the world, essentially, the rest of US employers. All right, so what does the final rule say? So with respect to a worker, it's very broad. So employees, independent contractors, interns. So again, other than senior executives, the definition is basically, and the reason for it is it's an unfair method of competition for a person to enter into or attempt to enter into a non-compete clause, 1. 2, to enforce or attempt to enforce a non-compete clause, or 3, to represent that the worker is subject to a non-compete clause. So it's not only telling someone, not only having it in writing, it is saying, okay, if you come to work for me, you can't go work for other people for a year, or you can't work in the city of Charlotte. So it covers verbal communications of telling an employee that you're under a non-compete if you come work for me. So the kind of highline or the highlight is virtually all pre-existing and future U.S. non-compete agreements are and will be banned and unenforceable, with the exception of, as I said, pre-existing non-compete agreements with senior executives. The benchmark is making more than 151,164. So just keeping kind of $150,000 range, just generally speaking, as a benchmark. And there's a few other exceptions, which we'll talk about. And then it goes into, excuse me, what is a non-compete clause? And it's defined as a term or condition of employment that prohibits a worker, penalizes a worker, or functions to prevent a worker from, Romanet 1, seeking or accepting work in the United States with a different person where such work would begin after the conclusion of employment that includes the term or condition. That's a fancy way of saying that once you stop working for someone, if you would be prohibited from working for someone else, then that's what that is. Operating a business in the U.S. after the conclusion of the employment that includes a term or condition. So not only can you, excuse me, not go work for someone else, you can't open your own business for that. And then it clarifies that term or condition of employment includes a contractual term, a workplace policy, written or oral. So you can't slide it into an employment manual, just, and let's say that they sign an acknowledgement of employment, or, this is kind of your term sheet. And, many of your terms and conditions of your employment are in this other thing called an employment manual that you need to go read. And then you sign something that says, I've read the employment manual, which many people don't do. I mean, it is what it is, but so that is now illegal. An interesting aspect of this is that you can't just sit back. If you have employees that are under a non-compete, you can't just say, okay, well, I won't say anything, or, I know that I can't put a non-compete in my future documents, but I'm not going to say anything. So it requires you to go and tell them, hey, by the way, I know you signed this 2 years ago. If you leave, well, first of all, you can compete with me now. And if you leave, you can go and compete with me down the road. I think there's going to be clarification that an interim non-compete is not invalid. I mean, it's not you hired somebody to do something, you don't want them to compete or do other work while you're paying them money to do that. So I have a feeling that's going to be clarified. It's not necessarily as clear as it should be, but definitely post termination, post separation employment would be included in that. Exceptions to the non-compete include, and this is something that it has already been in existence, so it's nothing that is new. I'm glad that it remained in here because there's a possibility that they would obliterate this exception, which is that for buying and selling of businesses. So whether it's a stock transaction or an asset transaction, where it still is fair that if you're going to pay somebody a lot of money to an owner or owners of a business, or you're going to buy all of their assets, that part of that money is consideration for benching them and for keeping them out of the game for a period of time because you're buying that business, you're buying that goodwill. And is it really fair for someone to be able to go pick up, sell the business and go 2 miles down the road or even closer or even further and open up the same kind of business? So those things are still out of the realm of in it being invalid. So they are valid. Other exceptions are where, let's say that you violated the non-compete prior to the effective date of this rule, you still have a cause of action, even though the effective date, like the trial or the resolution of it, occurs after the effective date that this rule comes into being, which hopefully is never. And then if this is interesting, this is so gray. A non-compete attempt to enforce a non-compete agreement with a good faith basis to believe that the final rule is inapplicable under the circumstances. That's basically saying if you think you fall under an exemption for whatever reason, then maybe it is enforceable. And then there's one that since I do a lot of franchise work, that everyone is happy about in the franchise world, which is it does not apply to a non-compete that's in a franchise agreement that says you franchisee cannot compete if we terminate this arrangement. Now, what is unclear, but I think is implied, is that that applies to owners that are also employees. I do not think that would apply to non-owner employees of franchised units. So again, I think there'll be some clarification likely that's needed about that. And actually, I'm going to DC next week for a couple of days to the International Franchise Association conference, which is a bunch of franchise lawyers getting together and commensurating over and lamenting over the things that we have screwed up in the prior year and what we're being told by the state regulators not to screw up in the following year. And so I'm sure that we'll be talking about this when we get there. Let me give you a little bit of perspective from the FTC side of things. And this was published on their website. So under this rule, the FTC adopts a comprehensive ban on new non-competes with all workers, including senior executives, but subject to that exemption. And then they go through what I talked about before, 120 days from publication, and specifically that it violates Section 5 of this rule. It talks about the senior executives and gives some statistics. So fewer than 1% of workers are estimated to be senior executives under the final rule. So what they're saying is there's a lot of people who might think that they are senior executives, but for one reason or another, either they don't meet the monetary threshold or they do not, their duties are not sufficient to put them in that classification. Just because you have a title doesn't mean that you are in because you've hit over the $151,000 mark, or I think it's 154, right? No, 151. And so it has to be a look back as to seeing what exactly that executive is doing, because it's essentially a two-pronged test. Again, senior executives is 151,000 who are in policy-making positions. And then, in order to kind of justify their position, they throw out some more statistics that FTC estimates that banning non-competes will result in reduced healthcare costs between 74 and 194 billion, that's with a B, in reduced spending on physician services over the next decade. And I want to discuss that a little more in depth, like why that seems logical on some aspects, but maybe not so much on others. New business formation, 2.7% increase in the rate of new firm formation, resulting in an additional 8,500 new businesses created each year. Basically saying that, okay, if you are not prohibited from starting your own business, then there's going to be new business generation because you're going to go file the articles of organization, your articles of incorporation in your respective states to start a new business, and you be your own boss kind of thing. A rise in innovation, an average of 17,000 to 29,000 more patents each year. This reflects an estimated increase of about 3,000 to 5,000 new patents in the first year non-competes are banned, rising to 30,000 to 53,000. So a significant, it's so 10% increase, and then to the full increase in the 10th year, an increase of 11 to 19% annually over a 10-year period. The reason that is maybe is not readily apparent is that when you are an employee of a company, your employment agreement should say, if you invent anything while on our time and using our technology and using the know-how we're about to give to you, then it's ours. It's not yours. And you basically have signed that over. And you can't compete and you can't use these things. And so if you're able to develop something and quit and not have any obligations back to the company to not compete. Now, it's different than, I'm not proposing that it's okay to steal your company, the former company's stuff. If it's their stuff, it's their stuff. I'm talking about that things that you think about at 1 o'clock in the morning and you're out tinkering in your garage because you have an engineering propensity and you go and you invent something. Companies can say, well, even though it was not technically on the clock, you're using our stuff, and you cannot go and now monetize your idea because the genesis of it was while you were working for us. That's a very loosey-goosey 30,000-foot level explanation of patent rights. So please don't go and, okay, well, now I can go keep my invention quiet and go use it, implement it down the road when I know I'm going to be working for myself in 18 months or so. Another statistic, higher worker earnings, 400 to 488 billion, again with a B, and increased wages for workers over the next decade. So an average worker's earnings will increase an estimated extra $524 per year. The reason for that is that they're saying that you will have to pay more to people to keep them loyal by persuasion rather than basically locking them down from going elsewhere. So we get a lot of this, and you probably have, and I know, Gary, you guys have experienced this too, where you have a client that comes and says, well, I don't like my job, but I have this little thing and employment agreements and non-compete kind of thing. But I can make more over here doing something differently or doing it for a competitor maybe. And so this is in theory going to increase the need for higher salaries to incentivize people to be loyal because you don't have them locked down with handcuffs in the form of a non-compete restrictive covenant. So there are some groups that are fighting the FTC, and this is just the front end of it. There's going to be many more, I'm sure. But there's two powerful lobby groups that actually filed a lawsuit last week against the FTC. I think it was the U.S. Chamber of Commerce and then this Business Roundtable. I believe it's a national organization, and then two Texas business groups alleging the suit. In the suit, the FTC oversteps its authority. And then there's a quote that says, "This rule reflects an arbitrary and capricious," which is a very lawyerly term. You see that a lot of times when it's, okay, certainly this is not reasonable because arbitrary and capricious, that's a law school word, law school phrase, exercise of the commission's power. There's also this doctrine, the major questions doctrine established by the Supreme Court, which effectively curbs federal agencies' ability to craft new regulations. So there is some rules about making rules, and they're alleging that they have violated the rules to make the rule. And then the other side is, the FTC, again, all those things that we just talked about. And then kind of an interesting angle to that is the impact on healthcare workplace workers. So there's always been kind of this equitable doctrine in a non-compete that if was it Doc Hollywood with Michael J. Fox, and he was a city doctor that got stuck out in the country. And it made me think about that, because that's kind of the scenario where you have a doctor that has a specialty that is, and there's no one else around him for 40, 50 miles that can do what he does, but it's in the burbs of, a big city. And so imagine someone going down to like Rock Hill with a super specialty, and it's within the non-compete of a Charlotte-based uptown, wherever their office is. And so, and this wouldn't happen because Rock Hill has all kinds of specialties, but let's just say that our whole area isn't as developed. There would be a good argument for that doctor to say, well, you cannot, in the interest of public policy and public health, you can't stop me from going to work here for two reasons. One is they need the specialty. Relatedly, they can't drive all the way up to Charlotte. It's just economically not feasible for this community. And they're not going to do that anyway, unless they really have to. And it's fair to have my practice here. So that would be the argument for that. So that is also one of the arguments that's made for having this ban and making it official, making it an issue of law rather than of equity. So let's see, let me give you some statistics. Between 37 and 45% of physicians are affected by non-competes, according to the AMA. Of the roughly 26,000 comments the FTC received on the rule, a significant number came from healthcare employees, especially doctors, particularly in rural areas, where there's questions about enforceability of, as I said, a bunch of comments that said, I signed this, but it's not like I was exercising a real choice. I felt coercive. That goes beyond the healthcare industry. It's kind of like, okay, sign this or else you're not going to get the job. And then many people will say, I'll deal with it if the time comes. And, maybe I can negotiate my way out of that restricted covenant. Even healthcare workers making a decent living, whatever that means, feel that they did not have bargaining power, and that was quoted here. The debate over non-compete agreements did divide the healthcare industry.
Yeah.
So I'm not
There we go.
setting forth that everybody was like, okay, yeah. I mean, you can think about the other side of it, not the doctors, but the administrators, the practice group heads, the owners of practice groups that are, are like, okay, well, what should I be, how am I going to protect our practice here? So, it is divided. Harspel argue that agreements are necessary to recruit and retrain workers. And then the funny quote is, the only saving grace is that this rule will likely be short-lived, with the courts almost certain to stop it before it can do damage to hospitals' ability to care for their patients and communities. Again, more criticism. Doctors are trapped in places where they may or may not feel good about the care that they are able to provide. And they talk about rural markets again, kind of thing. What is also clear, again, kind of bringing in the concept of sale of a business or sale of assets, sale of the stock, that was also brought into this article and this discussion, that the sale of a physician practice it's a business. So that is going to the non-competes that are required upon the sellers are going to be enforceable mostly. Now, when you get into professional services, lawyers, doctors, etc., there's all other issues about enforceability of non-competes, but it's not based on the fact that you're not entitled to compete. It is more of the patient, the client has a choice on which service provider they want to provide them services. They should not be forced to use a service provider in the same company, in the same firm, but someone that's different, that hasn't been doing the work for them. You're not tied down to your service provider, and enforcing a non-compete in the force of in the sense of non-solicitation is unenforceable in many cases. That's not to say that we don't have a lot of fights about professionals and enforceability of non-competes and what that means. And especially when there's, okay, well, you don't have to abide by the non-compete, but there are financial consequences for doing that, which is a different way of saying you can buy out your non-compete pursuant to the operating agreement. And so then you have to analyze whether or not that is, a violation of non-competes with relation to professional services. So I'm going to stop there because that's a lot. I want to also talk about, the overtime exemption issues, but Gary, I don't know if there's anything you want to throw into
So
that
the
mix.
we were having technical difficulties here, I think with all the construction going on across the street, for some reason, we get pumped off of the internet. So that happened to me, but I did post in the chat to everybody. There's an episode, it's episode number 80 or 98 on the Anything But Typical podcast, and it has the CEO and founder of Delta V, which they are the forensic scientists, if you will, for all major truck wrecks. If there's a 18-wheeler or big truck that's involved in a fatality or a wreck, Delta V is the go-to group. Well, the reason I put that in the chat, Brian Anders is a really interesting cat. He's a really good guy. And he had a non-compete that was 150-mile radius out of, from Charlotte or Greensboro. I can't remember, but I think it was 150-mile. And he's just a guy of integrity. Instead of trying to fight it, because he didn't come, from money or whatever. And I don't know where he fit on that $151,000 threshold but there were, this legislation wasn't enacted yet, nor is it now yet. Who knows? But he bought a single engine airplane and flew 151 miles plus every day so he could do work and he could start his business. Like, no kidding. And his wife, she has Barefoot Investigations, Jan Barefoot. She was also on the podcast, separate one. So she was like, go for it. And, it wasn't like they were just rolling in the dough, but that's what they had to do for him to go ahead and do it and not tie up a ton of money and time with legal fees and fighting that non-compete. So that's probably one of the most extreme examples I've ever heard of somebody going, all right, I'm going to honor this non-compete. And he has built an amazing company with Delta V, but and I think he had his pilot's license already, but he's like, we're going to go for it. And they did. So it's pretty cool. So that link on Spotify, it's on all the major podcast channels, but you guys can check that out if you want. I'm also thinking, as we're going into overtime stuff here, thank you, Randall, for sending us, some additional legislation that's coming, that Biden is proposing on national rental regulations. And boy, that's a bit of a powder keg. So I think it might be worth seeing if we can get that big old shepherd's crook and hook and getting Michelle in here next week. Because that one, I mean, there's just a lot of insanity. Like, if you own stuff, you have no rights. But if somebody wants to break in and claim it, they have rights. I mean, this is ridiculous. So the insanity has got to stop. But let's if there are any questions on what we've already been talking about with non-competes or comments, hit us up. Otherwise, Jack, I'll monitor those things. You just go ahead and keep locking and loading into the overtime.
All right, sounds good. And yeah, just a comment about that national legislation for evictions. I mean, we have that problem here in Mecklenburg County with so if somebody who is a short-term tenant, like at a hotel, once I think you hit over 31 days, you become a resident. So, that's usually not a problem in like the Marriotts and stuff like that, but other hotels around here kind of thing, of property owners, because I deal with a lot of hospitality clients who are hotel owners, both the marquees ones, the name brand flags and others. So, but yes, we definitely can talk about all kinds of, and both Michelle and I will have plenty of war stories to
Yeah.
share about that, as you might expect.
Yeah.
So, all right, here is the background on this. On April 23rd, I'm going to go into my reporter mode.
Oh, there you go.
On April 23rd, 2024, the United States Department of Labor, the DOL, issued its final rule significantly increasing both the standard salary threshold for exempt employees employed in a bona fide executive administrative professional capacity, known more commonly as EAP, and the annual compensation threshold for highly compensated employees, HCEs, under the Fair Labor Standards Act. The final rule, which is expected to expand overtime protections to approximately 4.3 million employees in the first year, will be implemented in two phases, the first of which begins in less than 3 months on July 1, 2024. All right, so I have a link and I'm going to put it in, and I don't think I can send it to everyone in the chat, Gary. So I'm going to put it in here because I think it just goes to hosts and panelists. But one of my partners just
You can
published.
actually,
Oh, I
okay.
can change it.
Yeah, you
Okay,
can
sorry.
change
And
that.
then,
Let me see.
and I think you said you had posted a link in the chat, and I don't see that in there.
Oh,
If
then maybe,
maybe when you were offline, there
yeah.
goes.
So I'm going to copy that one and I'm going to go ahead and put it in. And
Okay,
go ahead, you keep going, and I'll
that's
put
fine, and it's
yours
it's
in
there so you
here.
don't have to remember all these numbers. Okay, and so, but effective as of July 1st, 2024, white collar and computer workers, $844. Well, let me start with what it is now. For white collar exemptions, and EAP, it is $684 per week, which is $35,568 annualized. It will increase from 684 to 844 per week, which means it goes from 35.5 to 43.8. And that is for the white collar exemptions, which is executive administrative professional. Now, for highly compensated employees, that number goes from 107,432 to 132,964. That is probably the number that people are more interested in, because that is the number that determines whether or not that you are typically exempt or not exempt on the dollar amount. Meaning, are you, kind of a inline employee that's making less than that, so you would get paid overtime when you're on your computer on a Friday night or on the weekends. That should count as overtime, and those kind of things.
What
So,
were those numbers again for the white collar?
so for white collar, it's going from 684 per week to 844 per week, which translates from 35,568 to 43,888 annualized.
Okay.
And
But then
then
there was another one.
the highly compensated employee goes from 107,432 to 132,964. And that's
So how
just,
do they get these numbers? Well, I guess the 964, it's all extrapolation based on the hour, right?
it is, yeah.
Yeah.
But as far as where they get the numbers from, I don't know. I mean, there's algorithms and there's averages and everything else that they come up with. There was, you might remember some attempts in earlier years, both under Obama and under Trump. The one under Obama didn't pass. It was pretty extreme, the increase. The one under Trump passed, but I don't think it passed very easily. There was a lot of resistance to it. And then, so we talked about that it's a two-step. So then the next set of numbers are that it's going to go from 844 per week to 1128 per week for white collar. And then on the 132,964 for highly compensated, it goes to 151,164.
Wow.
And then that stays in place for 2 years. And then in 2027, they start doing some adjustments, and then it's every 3 years then after. So it'd be 2027, 2030, 33, 36. At least that's the plan. So the final rule, so, we're talking about core compensation. We're not talking about benefits necessarily, but it has been permitted and will continue to be permitted to throw up to 10% of discretionary bonuses, incentive payments, and commissions to satisfy the threshold for the white collar exemptions. So you can't use all of it. You can use a very small portion of it to throw back in and pretend like it is core compensation to meet these numbers that we just talked about. Okay, and then so this, the client alert that you now have access to or will have access to goes into what is the qualifications for well, further qualifications as far as being a white collar exemption outside of the monetary restrictions. So this is kind of the other side of it. So white collar exemptions must be paid on a salary basis, paid at a rate not less than the weekly salary threshold, which we just talked about, and perform certain primary duties specific to each exemption. So, it's, again, executive, administrative, professional, and there's different standards that you have to meet in order to be classified as being in that category. For the highly compensated, exception, employee must receive total annual compensation, as we've talked about, have primary duty that includes performing office or non-manual work, and customarily and regularly performs at least one of the exempt duties or responsibilities of an exempt EAP employee. So it's saying that all of your duties don't have to be exempt. At least one of your duties has to be within the exemption. So to make it clear that, okay, you can be doing things that non-exempt employees would do, and that's not going to disqualify you from being in this category. So if you are out there, I don't know, mowing the lawn or something at the front entrance of your facility, but then on Friday, Saturday night, you're dealing with payroll issues, so that's kind of, bizarre examples, but kind of the polar ends of that kind of, that definition. I did talk about, okay, so here it is. I'm talking about the Obama administration publishing a rule back in 2015, and that got struck down, and then the Trump administration published a rule in 2019 that became effective in 2020, January 1, 2020. And it is an example of the efficiency of our judicial system. And I feel bad, since I'm actually an officer of the court, I feel bad saying this, but not really, because it's true, is that this 2020 Trump administration rule is currently, an appeal is currently pending in the Fifth Circuit Court of Appeals. It's May 2024. So, it's like, okay, have they not figured it out whether it's going to be valid or not? But that brings up a point that, with all of this stuff, the two kind of things that we've talked about, there's going to be challenges. And so similar to what happened there's happening with the reporting act, the Federal Reporting Act, that there was an appeal, but it was the federal stay only applies to the plaintiffs in that case, so they don't have to comply with the Transparency Act. Everyone else has to, at least for now, until this gets resolved, or until there is a stay that applies to everyone. So it's, status quo is, we've been reporting, as I said last week and in weeks prior to, it's now we're in, 3 months, 4 months into the year, that those entities that we formed in January and February now have to be reported. So we have to get passport photos, driver's license photos, and all those things that are required to report on. So we're doing all of that. The let's see, okay, some other statistics as far as the cost to, it's going to increase, obviously, the cost to businesses. We've seen kind of a microcosm of that in California, where they've raised the minimum wage. And make no mistake, who is going to bear the brunt of that? It's the consumer.
Consumers.
they're going to be paying more for the
$20 Big
Macs.
Macs.
Exactly. They're going to be paying more for their services. They're, you know, the employers are not going to, businesses are not going to take that on their backs. So that's what's just going to happen. I think that's what is going to happen here. Now, the free legal advice in this is that you need to go now, you need to be familiar with, sorry, the free legal guidance. I can't believe I said the word advice, but it's
Yeah,
not
I
advice,
was
it's
gonna
guidance,
say,
right?
I was gonna throw the lawyer card
Oh
out.
my gosh. I can't believe it was like 5 seconds before you said anything.
I know. Well, I just wanted to see how long it'd take you.
Oh my gosh. So the guidance is to know these thresholds, especially if they actually come into existence. And then you need to think about, okay, if there is, for example, an employee that is exempt, but they don't do a whole lot of overtime, you may want to put them into a non-exempt category. And if it's someone who is exempt, then you may want to, you know, so you need to look at your employment roster and how you classify them and where they're at and what duties they're doing, because you may want to adjust certain things based upon that. You may want to start paying someone more in base salary. Let's say there's someone that qualifies because of what they're doing, but now because of the raising of the bar of the number, now they're not you know, in the box of being exempt, you may want to consider raising up their salary to get above that exempt line so that they remain exempt. Or, you know, maybe again, you don't do that because they aren't getting a whole lot of overtime and you're okay with them becoming non-exempt employees now, not because of what they're doing, but because of what they're making to do their exempt duties, if that makes sense. That was a little circular, but so again, just keep in mind, you have to keep both of those things, the monetary aspects of it, but then also what is this person actually doing? And you need to monitor and make decisions and maybe do things a little differently, maybe modify some employment contracts and do those kind of things proactively to, you know, be more efficient and save on expenses potentially. So
So is this really happening on July 1, 2024, even though that's less than 120 days? I know that the non-compete thing was 120 days after publish, but
yeah, I mean, it's the rule is published. And so until someone stops it, then it's, you know, it's on the books and it will proceed forward
okay.
on those dates. But I like everything else, it's going to be subject to challenges. You know, this article says that the final rule will certainly face court challenges in the coming weeks. What happened in 2016 when they were fighting the Obama administration rule says may shed some light. The DOL issued a final rule that would have substantially increased the minimum salary, and almost immediately multiple states filed suit to prevent the rule from going into effect. So you have, you know, the like the attorney generals of various states that will go and say, okay, you've overstepped into an arena that you're not permitted to step into. In that case, the Eastern District of Texas granted which is the federal court, granted the request for emergency preliminary injunction before the effective date and later granted a motion for summary judgment, meaning that they determined that it was unconstitutional, that they couldn't do it. Reason that the final rule would have made previously exempt employees eligible for overtime pay solely based on their salary level and not on the required duties test component. So apparently there was an issue that's why this one likely what the word on the street is that the first increase in July will probably go forward and the challenges may be unsuccessful because they did link those two components together. But when you jump from 844 per week to 1128, which you know, annualizes, what's that, almost a $20,000 increase, that's pretty significant and will probably be deemed too fast if I had to guess.
Yeah,
So
makes
that's where we're
sense.
at with that.
Well, you're right. We had enough to talk about today. I think let's just throw it out here, but this national rental housing proposal, I think that would be worth going into more, because I know even if we have a lot of business owners and a lot of individuals that we serve that have owned businesses or still do, that also have rental properties, and they have other, and this definitely impacts them based on what they're proposing. I mean, man, some of the crazy stuff that comes out of Washington, D.C. is mind-boggling, but and
I mean,
then
it's
whether
logistically difficult at the get-go because you have
right,
different laws in different states, and if you're going to put this national requirement of due process on it, it's not the same in every state. So you may be interfering with, I mean, some states may be more efficient than that. And I would imagine that if it were to get in, it's the more efficient of the two. And if your state's process or your county's process is not as efficient, then and that goes into also, even though it's a state judicial system, you have individual counties that are more efficient and more sufficient to handle cases, like the great state of Mecklenburg County, as people in Raleigh would refer to Mecklenburg County. Not that I do. I think I mean, but that is a very short way of explaining the animosity between Raleigh and Mecklenburg, because in Raleigh sometimes it's the great state of Mecklenburg that's trying to do stuff, and make put in toll roads and keep the tax money in Charlotte. Well, who's using the roads? It'd be Charlotteans that are using the roads. And so when we pay money, wouldn't it be good if the money actually stayed where the users are who paid the money, kind of thing. So again, I'm trying not to get political and go into the Adam arena of comments, but so I just some things just sometimes just don't make sense, and it's just readily apparent. So call it out for what it is. But yeah, we can talk about more about this legislation, and that will lead to discussions about dealing with tenants and dealing with holdover tenants and what you might be able to do to prevent that. But also as a tenant, what would be your rights, and what are your rights in just getting kicked out for I shouldn't say no good reason. The issue here is that usually and I know we're getting close to time, but just kind of as a preview, the real big issue here is when you have the default under leases is usually for non-payment. It's a monetary default. And so if you extend the process and you have a tenant who already is not paying, they're not going to now start paying you. So they're in there for rent free. And then
yep,
a lot of times when you get to the end, the landlord may win and get a piece of paper that says judgment, congratulations. Now, what are you going to do with it? You're going to be able to enforce the judgment and liquidate that claim against a tenant who already hasn't been able to pay you and has not been paying you, and probably is having other business issues. So that is the fundamental issue with doing something like this, which is that it doesn't address, and it exacerbates the really core issue, which is non-payment.
right. So Brenda had just sent me a note. Hey, didn't get the links, and I've been posting. It's funny because I was testing these links. The Spotify link, I was able to click, and it took me through to Spotify for that Brian Anders episode, if anybody's interested. But the Shoemaker one, when I clicked on it from here, it said page not found. However, when I just copied it and pasted it into a browser, boom, it took me right to your paper.
Okay.
So are you seeing it, Jack? Are you seeing it in the thread
I'm
from
seeing it
me?
with hosts and panelists, but not to everyone. And I see the one to everyone, the Spotify to everyone. So maybe you need to change the pull down for
Yeah,
that to
and
send it to
but I
everyone.
did. I've
Okay.
done the what's funny, I did I'm gonna try it one more time. But I've done the yours to
Yeah.
everyone
Wow. It does
multiple
say page not
times.
found. It must be a broken link. Maybe I didn't copy and paste it correctly.
The funny thing is if I take it and then I put it into that same deal and I put it into like Google browser, the Chrome,
Yeah, I
it
repasted it.
it works.
Okay. So maybe you do have to cut and paste it and put it in there, and it's
Yeah.
just not accepting it the way it is. Okay. Well, that's
Yeah.
fine.
So it's there. I would just say if you guys can grab it, cut it, and paste it into a browser, and it'll take you where where you need to go. So anyway.
All right.
All right. Well, thank you everybody for showing up. Spotify one goes here. If I can send a picture, no. If anybody needs any of those things, just let me know, and I will. I'll send you an email later on tonight. I've got meetings that go into kind of the wee hours tonight, but I'll be happy to do that. So I'll send those links. So
All right.
anyway, thank you everybody
Thank
for
you.
joining us. And next week, week 206. And I will not be here because I am going to be with my bride celebrating her birthday. That's actually my birthday too, but hers was last month, but we're going to celebrate a little delayed given the surgery that I had, but we're doing good. So you guys will take it, and hopefully you can get Michelle to join you as well.
I told her she has an open invitation whenever she wants to jump on into the chaos. So
She's been a good sport,
the
man.
romper room, you call it the romper room, right? So yes,
That's
she's
right.
happy to do it.
All right, guys. Well,
Mhm.
you all have a great day. Enjoy this beautiful weather in Charlotte, North Carolina, or wherever
Thanks.
you are.
All right.
See y'all. Bye bye.
See you next week. Bye.